Welcome to When Playtime is Over. Our goal is to stimulate thought and conversation, not to convert your perspective. Any persuasion is solely at your discretion and deliberation. For your consideration, we would like to offer George Floyd Part 2 of 3, Logical Reasoning. And as always, for those who are easily offended, emotions will not be needed. So please, before entering, check your feelings at the door. Facts and questions. Sometimes you must go backwards to retrace and unravel an incident, then proceed forward to a place of clarity. A review or reenactment from the end of the critical incident that claimed Mr. George Floyd's life analyzed in retrospect will reveal the points that were incriminating to all parties involved based on the visual evidence and the factual inference of the application of the law. Examination from the end to the beginning of the encounter is a very distinct way to isolate the mental state of mind, the mens rea or intent, so that it can be legally established. The criminality, the mea culpa or fault, can be best demonstrated by everyone's actual actions or inactions at critical times according to legal standards. Were these actions justified based upon what was known at that time, what should have been known at that time, or what was being observed throughout that time? Was it within the law and police procedure or a violation? Does the action's justification rise to the level of its application to the circumstances? Was it legally necessary and permissible? The answers all serve as actual testimony to the facts. According to the law, an inaction can also be an action when there was a duty to act. If there was an inaction, was there a duty to act? What action should have been taken, and how could that action have affected the outcome? As a fluid, evolving situation, the timing and chronological sequence matters greatly to the incident's legality and outcome. A diligent analysis of the timing and sequence will reveal critical and crucial determinations of criminality and culpability. Our methods will be to state the facts as we believe them to be true, and then ask the pertinent questions raised. In Part 3, we will examine the answers by deductive reasoning of the legal application of the law and police departmental policy and procedures, analyzing along with suggesting the obvious logical resolutions and interpretations. Facts. Mr. Floyd, while in handcuffs, was surrounded by 4 policemen and physically restrained by at least 3 of them at different times during the incident. He was removed from the scene by responding EMTs on a stretcher, presumably lifeless by all appearances. He was then transported to the hospital by the EMT unit. Questions. Who radioed in for medical assistance and at what point during the incident? How many policemen involved spoke with radio regarding medical aid, the reason for the request for EMT, and if requests were made to step up their arrival due to Mr. Floyd's physical decline? When stating Mr. Floyd's condition, was there any mention of shaving on his neck restricting his breathing? Was that due to an omission or a concealment? What was said during the radio transmission? What does the dispatcher recording and separate notes reflect? When was the supervisor notified and by whom? Did any other policemen involved make notifications to advise command? Were there recorded specialized channels that more sensitive information was communicated over? Did that happen by whom and at what time? If such secure channel communications took place, were they recorded and reviewed as they most likely should have been pursuant to discovery or deuces take 'em? What were EMT's dispatch communications? At what point did EMTs determine that Mr. Floyd had no vital signs indicating death? Was it before transport, during transport, or at the hospital by medical personnel? What life-saving steps did EMTs take, and how did Mr. Floyd respond? Once at the hospital, what life-saving steps were taken, for how long, and by who? What was the information given by the EMTs? Is there paperwork and interviews complete and consistent with that information? And when was Mr. Floyd's actual pronouncement of death? Were there real-time 911 calls from the public as the critical incident occurred, and how many? What was the content of the policeman's excited utterances, as excited utterances by any party are generally admissible in court as evidence of knowledge or intent? When was the location secured and treated as a crime scene with use of deadly force team or homicide unit notified to respond to the scene? Was deadly force protocol initiated and maintained specifically the separation of policemen and prevention of collaboration of statements prior to interviews? Was witness identifications and statements gathered? Facts. The primary policeman at this point has later been identified as Chauvin, an 18-year veteran of the force and the senior officer on scene. Mr. Floyd was pinned to the ground by his neck by Chauvin's left knee and left front shin area applied to the carotid nerve or artery area of the neck, transversing the windpipe, trachea, and larynx. The carotid artery is located on both sides of the neck. It does not matter which way Mr. Floyd's head was turned, it would still be exposed. The greater the torque or twist of the head, the greater the vulnerability of this neck artery to cause an unconsciousness or a fatal outcome. It restricts oxygen and blood flow simultaneously. This occurred for an estimated 8 minutes and 46 seconds, of which approximately 2 minutes and 53 seconds Mr. Floyd was unresponsive, presumably unconscious, and probably deceased. Despite public outcry, repeated warnings expressing concern from fellow policemen, and Mr. Floyd's very own police, Chauvin continued to apply pressure with his full body weight on Mr. Floyd's neck. The force continuum scale governs police use of force and the justification for what type of force is permitted to be used. Code Red is the highest level of threat and response category. Any neck restraint is classified as a Code Red on the force continuum scale, which categorizes the severity of its use as deadly force. With Code Red being the very highest threat level assessment, the resulting response can only be to preserve life or avoid serious bodily harm, but not to gain compliance. Any neck restraint is considered deadly force whether used against a policeman or used by a policeman. Due to the deadly force used on Mr. Floyd, which is understood to likely have caused or contributed to his death or inflicted serious physical harm upon him, the necessity or articulation for its use is a problematic violation from its initiation and certainly its continuation. It must be reiterated that he was handcuffed, hands behind his back, prone on the ground with 4 policemen surrounding him already searched and determined to be free of weapons. These circumstances do not support a Code Red response and neck restraint, regardless of however it was applied. It is not and cannot be justified according to the force continuum scale. There is, however, no dispute that Mr. Floyd's death was caused on scene before EMTs arrived with Chauvin's neck restraint a factor. Without Chauvin's knee as a factor, it would suggest that whatever other factors that contributed, Mr. Floyd would have succumbed to them at that very moment anyway without Chauvin's use of excessive force. It is the state which certifies the police academy and dictates the training criteria and curriculum which extensively covers the use of force. It is the city which swears in the cadets to become officers, which has the ultimate legal liability and also covers the use of force extensively. The use of force technically can be shots fired down to as minor as placing someone in handcuffs without incident, voluntarily, and with their utmost cooperation. The city gives authority to arrest for misdemeanors and issue citations. The state gives the authority for deadly force and to arrest for felonies, and that is why you go to county court for state charges. Although the state gives the authority to use deadly force, the city is responsible for that force and subsequent training once sworn in. By all standards applied, both state and city, force of any kind must be minimal force necessary to effect an arrest and should be discontinued as resistance lessens or it is no longer necessary. Keep in mind, it should be minimal force necessary. But in this instance, it becomes clearly not necessary to effect an arrest or gain compliance when Chauvin has his hand in his pocket and no need to even use his hands to control Mr. Floyd. Questions? question then becomes, was the knee justified in the first place based on the criteria for its use? If at any point he had been a code red threat, what level of threat did he pose or present once he was unresponsive and feared unconscious or deceased? Once Chauvin's knee was on his neck constituting deadly force, at what point was Mr. Floyd not a code red threat or actively resisting with the threat of death or serious bodily harm to anyone? Was there any discernible level of threat or fear of any kind with 4 officers present and Chauvin hands in his pocket while on Mr. Floyd's neck? Was there any discernible level of threat or fear of any kind with 4 policemen present and Chauvin hands in his pocket while on Mr. Floyd's neck? Would the threat level seem under control and become suspect when policemen feel comfortable enough to turn their back and not be engaged otherwise if any threat existed? Was Mr. Floyd given the opportunity to comply, and were there verbal commands and instructions issued for compliance? Had compliance and control already effectively been achieved when basically 3 officers had only secondary participation? Was Mr. Floyd's pleadings not an opportunity to ease the use of force, issue orders to comply, or a clear indication of his willingness to comply, as well as their responsibility and duty to discontinue or cause to be discontinued the use of force absent his resistance or the necessity? Despite all the concerns about Mr. Floyd's medical condition expressed before Mr. Floyd lay lifeless, what threat to 4 officers' life or limb was Floyd with his hands cuffed behind his back, prone on the ground on his stomach? If we are to believe their concerns for Mr. Floyd's medical condition, then wouldn't their actions be even more baffling? With Chauvin on his neck, when did Chauvin order him to comply? Or more importantly, what chance did Chauvin give him to comply? Even unresponsive with no pulse, the use of deadly force was not altered to the level of Mr. Floyd's lack of ability to resist or actual resistance, nor was there any possibly life-saving officer intervention. Was a taser, pepper spray, verbal persuasion, or other compliance techniques or less lethal options available? Why did Chauvin eventually take his knee off of Mr. Floyd's neck? Was it because Mr. Floyd was unresponsive or Chauvin had already killed him? No, that is unlikely because that had already apparently happened minutes before and confirmed by no pulse being felt by another policeman. Was the EMT's arrival the only thing that finally prompted him to remove himself off of Mr. Floyd's neck? Aren't illegal orders and criminal actions to be disobeyed and certainly not participated in or furthered in addition to expectations to be prevented? Isn't it understood and enforced in any military or quasi-military organization, including the police? Is it not your vow and commitment to uphold the law, not break it? The movie A Few Good Men is a prime example. They should have done something, and they had a duty to stop it, but they did not. If they had intervened, could maybe even after Mr. Floyd was unresponsive, could he have been still alive or potentially revived? Would Mr. Floyd more likely have survived if not for his encounter with Chauvin's knee? If we cannot say yes for sure that Chauvin was the cause of Mr. Floyd's death, then we cannot say no either for sure. Can it be denied that the fact is 3 policemen had a duty to step in and stop it, but did nothing? Instead of intervening at various life-saving points, did they not aid and abet in the murder by either actively assisting or providing protection and crowd neutralization as a deterrent to citizen intervention? Facts. Mr. Floyd is stretched out prone on the ground, handcuffed with his hands behind his back, face down after being placed there. Prior to being placed on the ground, Mr. Floyd was resistant to being placed in the squad car. Questions. Was the duration and events which occurred while placed face down on the ground the best course of action or options available, or an indication of indifference to unnecessary use of force? Was standing him alongside the squad car while maintaining the position of him being partially in the squad car more preferable given his level of resistance? Where were all policemen's role in attempting to get him in the squad car and removing him, placing him on the ground? Whose decision was it to place him prone, and why if he was almost fully in the squad car? At what point did they each participate in the chronological order of events, and why? Was there a detectable amount of frustration or agitation from the policeman towards Mr. Floyd? Was the reasonableness and level of force used lawful and necessary? Facts. The foundation of the law is what was known or reasonably suspected at the time. It governs probable cause and reasonable suspicion from the Constitution and the Bill of Rights down to municipal law enforcement and policeman conduct. The history of the policeman involved was not known at the time, just as Mr. Floyd's history presumably was not known at the time either. Their histories have no bearing on the consideration of the facts and motivations known at that time, certainly not overriding the actions which occurred then. The prevailing influence of histories is consistently demonstrating a propensity to act according to a previous pattern, a reluctance exhibited to refrain from an activity or implied tendencies during an incident. Histories are indications of conduct consistency and by no means restrictive of any number of actions or responses, both positive or negative, demonstrated which are inconsistent with that history. Mr. Floyd's criminal history revealed no prior consistency of code red behavior towards police personnel. Also, after the fact consideration for the two rookie policemen's lack of history bears no mitigating circumstances to avoid accountability, but may be an indication of their experience, but certainly not their lack of knowledge regarding appropriate force. Histories are indicators, but not always relevant implications that can be related to a current incident. It also has to be presumed that Chauvin's alleged previous racial undertones must be considered equally as Mr. Floyd's run-ins with the law of histories are to be a factor. Questions. Why would Mr. Floyd's history be unfavorable for him, but the history of the four policemen not be unfavorable for them as so revealed? So are we to assume the history of the two veteran policemen should be disregarded, the history of the two rookie policemen should be taken into consideration for clemency when Mr. Floyd's history held against him? How could the unknown history at the time somehow indicate that Mr. Floyd needed to be treated as a code red level threat in this incident? If Mr. Floyd's history were unknown at the time of the encounter, what bearing could it have had on the incident? If he were a priest, what bearing would that have had on the incident at the time if unknown? None. How could the incident not be judged on the actions of the participants at the time, at that particular time, which would render histories after the fact as irrelevancies? Facts. The policeman walked Mr. Floyd across the street without incident, and he seemed to have some minor passive resistance, but not actively aggressive behavior. He was handcuffed with minimal resistance and without incident or struggle. Mr. Floyd's actions upon being removed from the vehicle would not constitute resisting arrest or being combative because it did not meet the physical standard or require warnings to cease and desist or be placed under arrest for resisting. It appeared he was confused and more verbally resistant, attempting to have explained to him what was going on and turning to talk, but definitely not combative. The policeman said that they noticed a concerning level of distress upon handcuffing Mr. Floyd. Questions. Prior to being removed from the car, was Mr. Floyd properly advised as to what the encounter was about? If at the point of handcuffing Mr. Floyd, if he was showing signs of distress, why was he even taken across the street at all? If Mr. Floyd was showing signs of distress, why was he placed on the ground face down? If Mr. Floyd was showing signs of distress, why did Chauvin place his knee on his neck, further complicating his distress? What were the observed and conveyed physical signs and indications that were so concerning? What, how, and when were the signs escalating, indicating Mr. Floyd's decline? If Mr. Floyd was showing signs of distress, at what point was this radioed in, and with four policemen present, what assistance was he given? Is it prudent or customary to further restrict someone's breathing if distress is suspected? Was there a belief that Chauvin's weight on Mr. Floyd's neck was in any way assisting him or a benefit to his distress? Was the delay in requesting medical attention from the initial time of suspicion before he was brought across the street justified, or the whole distress story a fabrication to cover the cause of his death? What should have been the policeman's response? Was there any reason for any delay offering assistance, requesting EMT, or removing Chauvin off the neck of what you stated was an obviously medically distressed person? If Mr. Floyd was showing signs of distress, what distress signs were radio notified of to better inform the EMT dispatcher of the progression of his symptoms other than a grown man being on his neck? Suppose if he were suspected of having a heart attack, would you have placed him on his stomach with an over 200-pound man on his neck? Why was no aid rendered or attempted during his distress after he displayed no pulse? After displaying no pulse, did the other officers feel it was lawful and necessary use of force for Chauvin to remain on Floyd's neck? Facts. The policeman responded to a counterfeit $20 bill being passed at the store and received information that directed them to Mr. Floyd across the street. Almost immediately upon approach, the policeman escalated the situation by unnecessarily pulling his gun, revealing his disposition that Mr. Floyd knew it was a counterfeit bill. His demeanor was to prevent an escape or assume a threat level fearful enough to pull his service weapon, but why? You cannot just pull your gun on someone for a conversation. Was there a visible threat, or what justified this approach? Questions. Was the $20 bill marked and taken as evidence prior to approaching Mr. Floyd? Did they know the counterfeit protocol of notifying the Secret Service and recording the individual's information to be forwarded in a report? Should they have known that counterfeiting is a federal crime and is only arrestable by a federal agent or by prior federal authorization? Did they know that they lacked the authority to arrest him without proving he had knowledge that it was a counterfeit? Subsequently, was the counterfeit money found to have Mr. Floyd's DNA or prints on it confirming after his death that he had indeed possessed the fake? Could they or did they know if Mr. Floyd had knowledge that it was counterfeit or how he obtained it? Aren't the Secret Service only interested in printing operations and patterns, not random $20 bills in which they cannot prove knowledge or intent? With authority to investigate but not arrest, why was any force at all used? Is it common knowledge that counterfeit money is in public circulation and could conceivably fall into the unsuspecting hands of any law-abiding citizen unbeknownst to them? Is there a point where the crime does not fit the force used or even handcuffing for a nonviolent cold stand or questioning? Can the actions leading to his death be justified comparatively to the nature of the crime, public danger posed, or threats posed to policemen's safety being endangered? Was Mr. Floyd's race a factor in the handling of this incident? Were the other policemen in fear of Chauvin or his reputation? Would a conversation, patience, or verbal persuasion been more suitable, and is it also taught as a tool for law enforcement? Reverse engineering the circumstances and events reveals the highest contrast and logical continuity between what actually happened and what is said to have happened. Many times when a fabrication is constructed, it cannot stand the scrutiny of reverse analysis because it was constructed to make the pieces fit conceptually in a progression that only lends itself to conventional rationale. The contemplation of why would something be necessary if the previous assertion is true becomes an evident contradiction. If it were true, it would be no need for the subsequent action. For example, if they had truly thought Mr. Floyd was experiencing distress prior to his death, why would Chauvin continue his behavior or they allow it? It stands more to reason that they had the need to conceal something and quickly falsified an implausible explanation that contradicts their poor assertions, actions, and a chronological sequence of events. Their explanation leaves them exposed in too many areas lacking justification to be true and blatantly illuminates that if what they said were true, then countermeasures would not have been necessary, or otherwise their actions would have been consistent with their initial assertion. All indications are that their concern was for exposure from Chauvin's reckless and willful misconduct, which left them assessing what they were part and parcel of was improper. Mr. Floyd needing medical attention could only be exacerbated from the distress inflicted upon him by Chauvin and their inaction. Now that the illumination of contradictions have been identified by the question raised, then deductive conclusions of guilt can be examined and proven. Furthermore, did the punishment fit the crime or the tactics the situation? Keep in mind, even self-defense only allows for a force that neutralizes a threat and not beyond the danger which is posed. Thurston K. Atlas, Creating a Buzz.